What happens if you rely on public benefits where you need to have limited assets and then you receive a huge windfall of money? Do you have to give up those benefits or turn down the cash? Absolutely not. In this video, I'll explain how first-party special needs trusts can protect the money that you've received and also protect your public benefits like SSI, Medi-Cal, and Section 8 housing, even if your bank balance shoots up overnight. Let's dive in. So maybe you've received a windfall of money. Maybe your uncle left you, say, $200,000 as a nice gift, or maybe you got into a car accident and you have a litigation settlement. But what if you're receiving SSI, which has a countable asset limit of only $2,000, or a Section 8 housing, which now has a countable asset limit of $100,000? If you receive that money outright, you're going to be bumped off of those benefits, which can be really detrimental. We don't want that to happen. So what should you do? First, I want to talk about how to deal with smaller amounts of money. The first thing you can do is you can spend down that money. So let's say you receive like $30,000 of cash. If you get that money at the beginning of the month and you spend all of it by the end of the month on things that you need, the government only looks at what you own at the end of the month. Actually, they look at what you have on midnight the next month after you receive the money. So as long as it's all spent down and it's out of your account, it shouldn't interfere with your needs-based public benefits. The next option for dealing with smaller amounts of money is to transfer that money to an ABLE account. So if you receive up to $19,000, which this year is the annual gift tax exemption amount in 2025, then you can transfer all of that money to an ABLE account. You can set up that ABLE account if you're disabled before age 26, or starting in 2026, that age is going to go up to age 46. And then the money in the account won't count against your public benefits. Now, I like ABLE accounts so much that I've done 3 videos on them, so I encourage you to watch them. So now if you receive, say, $50,000, you can combine those 2 approaches, right? You can first transfer $19,000 into the ABLE account and then spend down the remaining $31,000 all within that same month, and then you don't have assets that interfere with public benefits. So there's a couple of other situations where you may not need a first-party special needs trust even though you're receiving public benefits. The first one is if you're receiving Medi-Cal benefits but not SSI or Section 8 housing benefits. In that case, the law changed in California recently, not in any other state, by the way, but it changed in California, so we no longer have an asset limit. So now Medi-Cal's only looking at your income. So there's a new type of trust called an OBRA 93 trust, which might work for you instead of having to set up a first-party special needs trust. And I have a video on OBRA 93 trusts that I encourage you to watch. Now, the other situation is if you're receiving Medicare benefits or SSI benefits. Both of those we call entitlement-based benefits because somebody paid into the system and they're not looking at your assets or your income to see if there's any limitation. You're entitled to receive those. So in those situations, you usually don't need a first-party special needs trust. Now, you'll probably need a revocable trust to avoid probate upon your death. And what you might want to do is name a family member or friend to act as trustee, or maybe a private fiduciary, to act as trustee of that revocable trust just to protect against financial predators. All right, but let's say that you are receiving some sort of public benefit that has an asset limit and you receive a lot of money. What can you do? Usually in that case, you would need a first-party special needs trust. Our ability to set up first-party special needs trusts started in 1993. And the name first-party special needs trust comes from the concept that you as the disabled individual, you are the first party and you are putting your own money into the trust. That's why it's a first-party special needs trust. Now, here's how it works, okay? You set up this trust and somebody else is named as trustee. You as the disabled person, you're not allowed to withdraw money directly, you can't demand money, you can't modify or revoke the trust. And because you don't have control over the trust or the assets, it doesn't count as your money. So any money in the first-party special needs trust does not count towards your eligibility for public benefits. So it's really wonderful that way.
Hello, did you know that my mom helps people all the way through the state of California from top to bottom? You'll give her a call.
Okay, so I'd like to go over the statute that actually created the ability to set up a first-party special needs trust. Let's take a look. All right, that statute is 42 U.S. Code 1396P, then D4A. So first-party special needs trusts are also called D4A special needs trusts. It's the same thing. So it says in D1, trusts established under D1, those are basically countable resources, all right? So those don't protect against public benefits. But then D4 has exceptions, and D4A is one of those exceptions. So let's read there. It says, a trust containing the assets of an individual under age 65. Okay, so that's the first point. You have to be under age 65 in order to create and fund a special needs trust. What happens if you're age 65 or older? Then you have to use a pooled special needs trust, which actually is described in D4C, which we're not reviewing today, but I do have a video on pooled trusts that I encourage you to watch. And it says, who is disabled as defined in this particular section. So that really means you have to be receiving SSI or SSDI benefits. You have to qualify as disabled by the Social Security Administration. Now keep in mind, that's not the case for third-party special needs trusts. You don't have to qualify as disabled for those, but for a first-party special needs trust, you do. Then it says, which is established for the benefit of such individual, the disabled person, by the individual themselves, their parent, grandparent, a legal guardian, or through the court system. Those are the only people who can set up a first-party special needs trust. You can't have your cousin or auntie or friend set up a first-party special needs trust for you. It has to be just those individuals, or you have to go to court. And then the state receives all amounts remaining in the trust upon the death of the disabled beneficiary, up to an amount equal to the total medical assistance paid on behalf of that individual. So basically, Medi-Cal wants to bring a reimbursement claim upon your death. So when the disabled beneficiary of the first-party special needs trust dies, any money remaining is subject to a Medi-Cal reimbursement claim for all the money that Medi-Cal has paid for the beneficiary's benefit during their lifetime. So they take out that money, and then any money remaining in that trust goes to wherever you've described in the trust. So you write out where anything goes. So basically, the government is making a deal. They recognize you need your public benefits. You need this income stream. You need this health insurance. But you got this money. So they're allowing you to protect the money and continue to receive these public benefits during your lifetime. But upon your death, the government wants their money back. So that's the deal they make with you. All right, so how do you set up a first-party special needs trust? Well, if the beneficiary is an adult, that is, they're age 18 and over, and if they have capacity, and if they're cooperative, they can set up what's called a seed trust. So that's basically a trust that has $10 when you set it up, and it doesn't have to go through the court system. Just one of those people can set it up, right? The individual or the parent or the grandparent set it up, and then once it's set up and signed, the disabled beneficiary can transfer their own money into that trust. So as I mentioned, for a seed trust to work, we need three things to be the case. First, we need the beneficiary to be at least age 18. If they're under age 18, then they don't have the legal capacity to be able to make that transfer into the trust, so it doesn't work. Also, they need to have capacity, which means they have to understand what's going on. They have to understand that they received this money and they want to protect it, and that they trust the trustee, the manager of the trust, who's setting things up. So they don't have to understand every single word in the trust, but they basically have to understand the concept. And finally, they have to be cooperative. They have to be willing to transfer that money into the special needs trust. If they don't want somebody else to manage it, they want to keep managing it on their own, I'm talking about the disabled person, then there's not much you can do about that. If you can't meet even one of these three criteria, then you need to go to court to set up that first-party special needs trust. And this is a lot more complicated of a process. In fact, at our office, we don't go to court to set up first-party special needs trusts. And mostly this is because I just don't like going to court in general. But I'm doing an interview with Mercy Hall, who's a good friend of mine and also a colleague. And she does a lot of these court petitions to create first-party special needs trusts. And she'll answer many questions that arise on this process. Okay, so once the trust is set up and signed, what do you do then? Well, first, the trustee should get a tax ID number for the trust. And then the trustee can take that tax ID number and a copy of the signed special needs trust and go to their favorite bank and set up an account in the name of the first party special needs trust. So that's where all of the first party special needs trust money will be housed. Then the beneficiary transfers their own money into that first party special needs trust. And voila, we have a funded first party special needs trust. So our office has been successfully setting up and funding first party special needs trusts for years. If you've received a lot of money and you need to protect it, and you meet those 3 criteria, right? You're age 18 and older, and you have capacity, and you're cooperative, or the beneficiary who you're looking out for has all 3 qualities, then we'd be happy to help you set up a seed trust for a first party special needs trust. And if you're helping somebody who doesn't qualify for those things, they're under age 18, or they don't have capacity, or they're not cooperative, then I ask you to watch my video interview with Mercy Hall, and I'll see you over there.
Did you know that my mom has a monthly newsletter? Subscribe by clicking below.